I call Mojo Mathers.
The Green Party is pleased to be supporting the Consumer Law Reform Bill. We are supporting this bill because it proposes the most significant changes to consumer laws in the last 20 years, because it increases protections for consumers and provides for more effective enforcement of these laws. We all know someone who has been ripped off or exploited in some way to buy a product they didn't need or a service under pressure, were quoted a misleading price, or the product did not perform as expected. And this bill will help address and close some of the more significant gaps and loopholes. I would like to mention here that the previous speaker notwithstanding, that I was impressed with the level of engagement by committee members and who seemed to put political differences aside and work for the best possible outcome. I also want to acknowledge the very high quality advice that we received from our ministry, who seemed to be able to produce a swathe of experts on a whole range of issues, from consumer goods to auction, from unfair contract to third-party payment. The submission process was very interesting, as there were very few submissions from individuals. The bulk of submissions were from businesses, energy companies, retailers and the like, as well as community and consumer groups. And I feel that this reflects in part the very complex and detailed nature of this bill. We are very pleased that the bill makes explicit that the Consumer Guarantees Act applies to internet sales sites and requires all traders selling goods and services to consumers on internet sites to identify themselves as such. The Green Party is also particularly pleased that the bill significantly expands the powers of the Commerce Commission, which will enable it to be more effective in carrying out its work. The committee has recommended compulsory interview powers for the Commerce Commission, and we strongly support this move, as these powers are needed to assist the Commission in obtaining documents and information that will allow them to properly investigate a company in a timely and cost-effective way. Some people have raised concerns that these powers may be too heavy-handed. We are satisfied that there are adequate safeguards proposed in the bill, in that the powers will only apply to investigations of serious offences, and the person being interviewed is protected from their statement from being admissible except for perjury charges if the case were to proceed to court. In addition to the increased powers for the Commerce Commission, there are a number of other areas in the bill that the Green Party are particularly pleased to see, including provisions preventing unfair contract terms in standard form contracts. Now, one of the things I particularly questioned about this is that whether that would mean they could rule out some very standard contract terms in banking contracts and insurance contracts and rule them to be unfair. And the reply was yes, they could do that. And that is one of a move that we hope will eventuate. However, the change that the Green Party is most pleased to see in this bill is the proposed prohibition on making unsubstantiated representations. And this provision will address an area that the Green Party have been concerned about for a long time. Many consumers base their purchasing decisions around claims such as having a reduced impact on the environment, 100% renewable energy, being biodegradable, resourced from sustainably managed forests, and so on. And such conscious consumers will often be prepared to pay a premium on the price that they pay for assurance of such claims. And one of the really frustrating things for us is that so many claims are actually not true or misleading or based on greenwash that we effectively have to become detectives or rely on pressure groups to do that detective work for us and in order to be assured that the claim is in fact true. Or we have to cross our fingers and hope. And we consider it to be a fundamental right of consumers to be confident that claims on a product are based on truth. An unsubstantiated claim also disadvantages businesses who make the effort and do the research to ensure their claims are based on fact. And currently, with the difficulty with the law as it stands now, is that it can be very hard or costly to prove a claim false. And this has proved very onerous on the Commerce Commission. And the crucial aspect about the proposed change is that the onus of proof about a claim will shift from the Commerce Commission to the business making that claim. Just imagine, businesses will have to prove that the claims that they make about their product are true. And it's disappointing that a significant number of businesses, such as Meridian Energy, argued that it would impose significant compliance costs and be too expensive for them to provide the evidence required. The solution to this is simple. If you don't have good evidence that your claim is true, don't make that claim. However, the committee did take on board concerns about possible impact on advertising creativity by recommending new clauses that make it clear that the provision does not cover representation that a reasonable person would not expect to be substantiated. And I'm sure that the makers of a very high-profile product will be relieved that they do not have to provide evidence of wing growth. The Green Party did have a concern that the Commerce Commission would not have sufficient powers to effectively enforce the prohibition on unsubstantiated representation, a point that was made by Consumer New Zealand. We considered moving an amendment to the bill to give the Commerce Commission the ability to issue power of substantiation notices, as is the case in Australia. And we sought advice from the Commerce Commission on this issue and have been reassured by the Commerce Commission's view that the substantiation provision in this bill is superior to the substantiation in the Australian consumer law because it's simpler, more easily enforceable and a better education tool. They have also informed us that they do not feel they need specific substantiation notice powers because they expect to be able to use the existing information gathering powers under Section 47G of the Fair Trading Act, along with, if necessary, the new compulsory interview powers to support the new prohibition on unsubstantiated claims. And for this reason, we are happy with this reassurance from the Commerce Commission and are confident that they will be able to enforce the prohibition and therefore are pleased to be supporting this bill. Thank you.
The Honourable Tau Henry.
Speaker, I suppose as a hard-out user of Trade Me,